Good morning, good afternoon, everyone. I'm very happy to be here to share with you the information about legal and practical overview of franchising in Asia. Let me introduce myself. I'm commercial lawyer of Tilleke and Gibbins Vietnam office. I have more than 14-year experience in practicing law and 10 years focusing on franchise. Our Tilleke and Gibbins is one of leading law firm in Asia, and we have now 7 offices in Bangkok, Hanoi, Ho Chi Minh City, Jakarta, Phnom Penh, Vientiane, and Yangon. We have been assisted many world famous brands for franchise, such as Banana Republic, Costa Coffee, Subway, Hertz, Gap, and Tesco. We assist them for franchise registration, localizing the franchise documents such as the franchise disclosure document or franchise agreement, and also help them in another franchise-related services. So my objective today is to provide you recognize the different perspective of franchisor and franchisee, to raise legal issue to be aware of when starting or offering franchising activity, to share with you some do and don't for both franchisor and franchisee under the legal perspective, and provide you some general information on legal matter concerning to some Asian country. So let's start at the first topic, common legal issue in franchising. Next slide. So what does franchise means? Yeah, each country or each jurisdiction will have its own definition, but in generally, this franchise means permission to use owner IP and business model to sell the goods or provide the services. And the franchisee agree to sell goods or provide service by the method and procedure instructed by the franchisor. And the franchisor agree to assist franchisee through activities such as training, advertising, promotion, and other advisory services. Actually, all of these elements will be shown and provided in the franchise agreement. Many franchise agreements will have the term and condition of the right and obligation of the franchisor and franchisee. And in the franchise agreement, the franchisor also lists out the trademark, grant the IP right that they grant to the franchisee for doing the franchise in the territory. This slide shows the common goal of the party. When doing with them, we found that they want to meet the monetary benefits. The franchise agreement should clear contact and framework for long-term relationship between franchisor and franchisee. They must build the trust and maintain confidentiality, and both parties must protect the IP. And one of the issues that both parties also need to be discussed is about method of dispute resolution. This relating to whether the dispute can be resolved by the court or the arbitration, local court or foreign arbitration. So I will talk more about this in the next slide and next topic. Next slide, please. Let's go to the different perspective. This table just show you some example of the different perspective of franchisor and franchisee. For example, the franchisor may want to limit the scope of the business or the product service that they will grant to the franchisee, and maybe the franchise rights just only the non-exclusivity. For example, they may be grant to the franchisee the right to operate franchise in the north of the country, but for the south of the country, they can sign the agreement with another franchisee. So this means that the franchisee, if they agree with this, so they will have more competitor. So that's why the franchisee may want a broad license to block competitor and broaden opportunity, and this should be exclusivity. Here are some other example of the differing perspective between franchisor and franchisee. It's relating to the license fee, about the franchise fee, or the cost, or the expense that who will be liable. For example, the franchisor may want to protect its IP as franchisee expense, and if there are any infringer, it should be stopped at franchisee expense. But the franchisee may want different. They want that the franchisor to find infringer at franchisor expense. But this the point that both franchisor and franchisee can negotiate and discuss during the franchise agreement. Yeah, so this will be about the common question for both franchisor and franchisee. So when the franchisor decide to expand their business to a new market, so what the question that they need right, or they should ask. So we suggest that a franchisor must quote the legal, regulatory, and tax indication of a potential franchisee territory. So next slide will be the list of the questions. Next slide, please. So the first question that we usually receive from the franchisor, this is, does a franchise need to be registered or licensed in the country? This is a lot of Asia country request that before granting franchise into the territory, the franchisor must register this their franchise system. For example, Vietnam, Cambodia, Malaysia, and Indonesia will request that the franchisor must register their franchise system before granting the franchise into territory. Meanwhile, there are some other countries that not request this franchise registration, such as Laos, Thailand, or Korea. We will talk more in the third topic. So another question the franchisor should raise, what are the qualifications of franchisor and franchisee? For example, Vietnam will request that the franchisor must have been in business at least 1 year. The franchisor does not need to establish any commercial presence in Vietnam, but they need to satisfy 1 year requirement. Meanwhile, the Malaysia will request that the franchisor must have been experienced in franchise business at least 3 years. And for Indonesia, they will request the franchisor must have 5 year experience in business. And so this is quite strictly, so franchisor need to research the law and comply with the requirement. One of the other questions very common is that, are there any pre-disclosure requirements for franchisor? Many Asia countries request that the franchisor must provide the franchise disclosure document or franchise agreement in advance to the franchisee. For example, Vietnam will request this. This is about 15 business days before signing the franchise agreement. And some other countries will request this period is about 10 days or 2 weeks. So please check with your local lawyer for this matter. One of the key issues for the franchisor to take note of is about the register of the trademark in order to enter into franchise agreement or to register the franchise. This is because the trademark will prove that the franchisor has the right to grant the franchise in the territory, or prove that they are the owner of the trademark. So many countries will request that the trademark of the franchising system must be registered Or for example, like Vietnam, the franchisor, foreign franchisor, when register their franchise system, must submit the certified copy of the trademark registration or the recognition of international trademark. Some other question will be relating on ongoing reporting requirement or the exchange control, withholding tax, and what is the applicable law or jurisdiction for the franchise agreement. This because many foreign franchisors would like to use their law country or their arbitration in their country in the franchise agreement with the local franchisee, but some country maybe not allow this. For example, for Indonesia, the franchise agreement must be governed by the Indonesian law. Or for Philippines, the foreign law or foreign arbitration may be not enforceable. For the franchisee, similar to the franchisor, we also suggest that before embarking on franchising opportunity, franchisee must understand the legal, regulatory, and tax implications that may be exposed to. Yeah. So, what the question that franchisee should raise or should take note of? The first question is relating to the ownership, the franchisor ownership of the IP right. Does the franchisor have ownership of the IP right, for example, like trademark, so it can legally license them with no one else have any claim to them? This is quite important because almost the franchise system will associate with the trademark, and this is to prove that the franchisor have the right to use the trademark. And we found that in practice, many cases that the franchisor does not register the trademark in the country, and in IP perspective, their trademark had not been protected in the country, and the validity of the trademark can be challenged by the third party. The second question is about, does the franchisor hold or require license for franchising in your country? This also because there are some countries require the franchisor must register the franchise registration, or they must obtain some sub-license like for the food or for the healthcare or for education. So depending on the requirement of the local law, you should check with the franchisor and request them to provide or require license. Some other question will be related to the right granted territorial, like exclusive or non-exclusive. How long of the term or period of franchise agreement? What are the specific payment, royalty, license fee, or insurance? This because, like Robert shared in his presentation, many fees will be paid by the franchisee, including the franchise fee, the royalty fee, the training fee, or advertising fee. So you should care about this one. So let's move to the top 5 do and don't of franchising for both franchisor and franchisee. Yeah, these show some do and don't for franchisee. First, we suggest that you should investigate the franchise and franchisor through our way. Second one, you should review your franchise document, franchise disclosure document, franchise agreement very carefully. Please read every word. And third one is identify the fees and expense you will have incurred as a franchisee. Please ensure that you are aware any supply restriction, for example, how you can transfer the business and other major issues of the franchise agreement. The last one, that please ensure you have independent legal accounting and business advice about your franchise before signing. How about don't? The first one, don't agree on terms and conditions that you do not understand or which are ambiguous. This because normally the franchise agreement is very long. It may be up to 40 or 60 pages with the complicated term and condition. So and also because the franchisor may bring their standard form under their law jurisdiction to your country. So it may be difficult to understand. So please clarify this with them. And maybe the franchisor may say to you that the franchise agreement is standard form. They also apply to many franchisees, but actually do not be afraid to discuss or negotiate with the franchisor on terms and conditions of the franchise agreement. Every franchise agreement can be modified or revised. Number 3, do not accept any oral explanation of a confusing term. Everything should be in writing, so it will be help you in the future if there are any dispute, and in writing is easier for resolve the dispute. Like Robert said in his slide, do not rush into signing the franchise agreement. Time is very important, but do not rush in signing this. And the last one is just about you should respect and comply with the provision of the side franchise agreement. Next slide, please. About do and don't for franchisor. Or do. In practice, we found that many foreign franchisors will run the due diligence on the franchisee. They will do the research about the franchisee activity, whether they have a good reputation or bad reputation in the country. This is to make sure that it will be not affect to the reputation of the franchisor in the country in the future. The second point is that please localize the franchise description document and franchise agreement if it's required by the law. Third one, please register the trademark and other IP right. This should be protect your IP right. Number 4, please keep evidence of any communication or agreement between the party. As same as the note for the franchisee, every evidence of communication or agreement between parties will be the evidence for handling the dispute in the future. And number 5, please ensure that you have independent legal, accounting, and business advice about your franchise. I will talk about a little bit about the don't. So, for example, don't rely on information which cannot be verified, evidences or commitment that are not in writing or recognized in the franchise agreement. Or for the number 5, don't forget to check the authority of the franchisee signing person and signing formality. This is because under some law of Asia country, only some franchisee authority have the right to sign the contract, and if it's not, the contract may be invalid. So please check this, the authority of the franchisee signing person. Next slide, please. Yeah, this come up to the last topic today. There's a survey of franchising law in Asia. Next slide, please. Yeah, the first is Vietnam. Vietnam had the regulation on franchise, and accordingly, the foreign franchise must register activity with the Ministry of Industry and Trade. Franchisor must have been in business at least 1 year, and trademark registration is required. For pre-disclosure requirement, the franchisor must providing the franchise agreement and FDD at least 15 business days. About the India, India does not have the specific law on franchise, and there is no requirement for the franchisor for registration to provide the pre-contract disclosure document to the franchisee. For Indonesia, they will have the law on franchise, and the foreign franchisor needs to obtain the franchise business registration certificate. The pre-disclosure requirement is 2 weeks, and one of the key note that the franchise agreement must be garnered by the law of Indonesia and registered by the franchisee. For Korea, they also have the Franchise Business Act. About pre-disclosure requirement, they request about 14 days, and they also subject for trademark registration because Korean is the first to file jurisdiction. Malaysia is have a similar to many other countries that they will request the foreign franchisor to register the franchise system, and the foreign franchisor must register the trademark in this country or in Malaysia. They also need to certify the 3-year experience in franchise business, and they also need to provide the franchise agreement and FDD at least 10 days before signing franchise agreement. Yeah, the last country I want to mention here is the United Arab Emirates. Similar to India, UAE does not have the franchise-specific law and don't have any requirement for franchisor to register with the authority. This is the comparison recent chart that I want to show you, so you can see that some questions related to the trademark need to be registered, or whether the license agreement need to be recorded, or franchise approval be required. Some countries will request and for registration, but some countries no. And the last column is about the what country requires a specific franchise law. So next slide, please. So we come to the end of my presentation today. So let's just I would like to summarize by saying that no two jurisdictions are the same. So please research about legal, regulatory, and cultural differences. Please, for franchisor, please ensure that you have adequate IP protection. This is because IP is easily stolen or misused. And the last one, that please seek professional advice. Legal documents such as franchise agreement or franchise disclosure document must be localized. So this is the end to my presentation. So thank you very much for interesting and attention. If you have any question and comment, please raise in the Q&A session and or email to us.